Hello, and welcome to the presentation on autonomy. In this presentation, we are going to cover the definition of the concept and make a few distinctions. Then I want to discuss the rise of autonomy in medicine. This is what I label in the syllabus the patient autonomy movement. Then I want to discuss cross-cultural issues in autonomy and run through some important arguments from philosophers. So part 1, the basics of the concept. Autonomy is one of the 4 master concepts for this course. Moral theory encompasses many things. Among the things it encompasses are theories of autonomy, justice, moral status, and naturalness. Autonomy is your right to control your own life. It is your right to make your own choices. As the book explains on page 41, your choices count as your own as long as they are voluntary, based on sufficient understanding, free of external constraints, and free of internal constraints. The first 2 of these are clear enough. We know what it means to do something voluntarily and with good information. The third item simply means no one is coercing you. You aren't acting because someone is pointing a gun to your head. The fourth item is a little more complicated. We say you are free of internal constraints when you are a competent decision maker. A contrast here might be someone who is addicted to heroin. They may not be able to make competent decisions because they are constrained by their addiction. The addiction is an internal constraint, the same way a gun to the head is an external constraint. Autonomy here is considered a right. The right exists even if other people aren't respecting it. So you have a right to be free of external constraints even if other people are in fact trying to control you. This is what Rousseau meant when he said that people are born free but find themselves everywhere in chains. In the terms that we looked at earlier, autonomy is a normative concept. To be clear that we are talking about a normative notion, sometimes we will refer to the right of autonomy or the principle of autonomy. Now, people sometimes also use the word autonomy descriptively rather than normatively. Someone who is enslaved does not have autonomy in a descriptive sense, even if they have autonomy as a right. I want to single out a particular aspect of this descriptive use of autonomy, and that is competence, or your freedom from internal constraints. Competence is essentially your ability to control your life well. It is important to single this out in a medical context because many patients have very limited competence. To be clear then, as we use the terms in this course, autonomy is a normative notion, while competence is a descriptive one. Once people begin thinking about autonomy, they quickly start thinking about autonomy in terms of principles. Most philosophers that deal with autonomy are fond of principles-based approaches to ethics. So autonomy itself then gets labeled the principle of autonomy. You have the right to determine the course of your own life. Now, in addition to the principle of autonomy, there are many principles involving restrictions on autonomy. The simple fact is that everyone cannot have complete autonomy because one person's autonomy can conflict with another's. People commonly say that my right to swing my fist ends at your nose, or in general that my rights end where your rights begin. Figuring out how to limit people's autonomy is an important part of ethical theory. This project gives rise to what your book refers to as liberty-limiting principles. These are discussed on page 46. The most generous principle covering the limitation of autonomy, and the one that gives the most free rein to individuals, is Mill's harm principle. Mill's harm principle says you can only restrict freedom to prevent harm to others. This is an important principle, and we are going to look in detail at what Mill thinks it does and does not include, which is actually a little askew from the way your textbook puts things. The important thing to see now is that for Mill, this principle is different from all the others because rather than being about what you can do to restrict autonomy, it's mostly about what you can't do. It negates all the other principles. We will return to this in a second, and then again in the final section of the presentation on the arguments from the philosophers when we look at Mill's argument for the harm principle. If we think it's okay to restrict someone's autonomy to prevent them from harming another, we might take this a step farther and say that we can actually compel people to help others. This is what your text labels the principle of social welfare. In some ways, we do this all the time. Taxes, for instance, can be thought of as a restriction on your financial freedom for the general good. You can also talk about the offense principle. The offense principle says that you can also restrict freedom to protect people from being offended. The textbook gives the example of involuntary confinement for mentally ill people who behave offensively in public, which used to be something that happened. Notice that this is only separate from the harm principle for those who do not consider offense a real harm. Someone might defend the censorship of offensive speech, for instance, by claiming that offense is actually a kind of harm. Implicitly, your textbook is denying that offense is a kind of harm. The main contrast, though, to the principle, the harm principle, is the paternalist principle. It says that you can also restrict freedom to protect people from hurting themselves. Laws requiring people to wear seat belts or helmets when riding a motorcycle are typical examples here. Your text goes on to distinguish two kinds of paternalism, and they are defined slightly differently in different places. When the terminology is introduced on page 46, they talk about regular paternalism and extreme paternalism. The difference here seems to be keeping people from hurting themselves and demanding that they improve themselves. This latter would be invoked if you not only wanted to require people to wear seatbelts, but also forced them to go on a diet, get some exercise, and generally become better people. The difference between regular paternalism and extreme paternalism would then be parallel to the difference between the harm principle and the social welfare principle, where in one you can compel people to prevent them from hurting others, and in the other you can compel them to help others. The difference between kinds of paternalism is phrased a little differently on page 51, where they talk about strong and weak paternalism. There, weak paternalism is just about acting paternalistically to people who are incompetent or who are about to do something really drastic. Strong paternalism is then about any more robust way of interfering with people's lives for their own benefit. Rather than trying to reconcile these two discussions, we'll just go with the former distinction and talk about regular paternalism, where you keep people from harming themselves, and extreme paternalism, where you force them to help themselves. Paternalism, as we will see, comes up all the time in medical contexts. For instance, it used to be common for doctors to lie to patients about their diagnosis or prognosis if it was thought that this deception was in the patient's own interest. For instance, a doctor might not tell a patient she had incurable cancer because it would simply distress the patient too much. There's another principle that we need to look at, even though it comes up less often in a medical context. The legal moralist principle says that you can restrict freedom to keep people from being immoral. Until very recently, there were laws on the books in almost every state banning sodomy. This is a restriction on individual freedom, and it's typically justified using the legal moralist principle. People felt that people who commit sodomy are being immoral, and so we should restrict their freedom to prevent that. In general, most laws about sexual practices are based on this sort of legal moralism. All of these laws were determined to be unconstitutional by the Supreme Court in a case called Lawrence versus Texas in 2003. And in general, legal moralist arguments are no longer taken very seriously in the United States. Let's take a look at Mill's own statement of the harm principle. This is from On Liberty, which you were assigned to read excerpts from. The excerpts are available in the Readings folder of Section 1. There is also a guided reading exercise which takes you through some of these excerpts. Mill's statement of the harm principle actually contains explicit denials of two other principles that we're talking about. He begins by talking about the harm principle itself. The only purpose for which power can be rightfully exercised over any member of a civilized community against his will is to prevent harm to others. Notice that this is not just about government interference. This is about any time one person tries to interfere with the life of another. So the government can act paternalistically, for instance with seatbelt laws, but an individual doctor can also act paternalistically by treating you in some way without your informed consent because he thinks it's in your best interest. The next steps for Mill are denials of the paternalist and legal moralist principles. As he puts it, his own good, either physical or moral, is not sufficient warrant to interfere with someone's liberty. You will also notice in the reading that for Mill, the harm principle includes the social welfare principle. This is what Mill says. There are many positive acts for the benefit of others which he may rightfully be compelled to perform, such as to give evidence in a court of justice, bear his share in the common defense, or in any other joint work necessary to the interest of society in which he enjoys the protection, and to perform certain acts of individual beneficence, such as saving a fellow creature's life, or interposing to protect the defenseless against ill usage, things which, whenever it is obviously a man's duty to do, he may rightfully be made responsible to society for not doing. So basically, Mill is just saying that there are many situations where not helping someone counts as hurting them. All right, the next section is the rise of autonomy in medicine. Over the last century, the concept of autonomy has become central to medical ethics in Europe and the United States. There has been some backlash against patient autonomy, largely because the idea of informed consent has been taken over by forms and lawyers. However, it is still fair to say that patient autonomy is still the backbone of medical ethics in Europe and the English-speaking world. It has not always been that way, though. For centuries, it was acceptable for doctors, scientists, and noblemen to conduct experiments on commoners without anything like informed consent. This really did not change until after World War II and the revelation of the Nazi experiments. Even after that, the idea that experimentation required informed consent did not really begin to take hold in the United States until the 1970s and the revelations about the Tuskegee syphilis experiments. So let's start by looking at the bad old days of medical experimentation. In the 18th century, it was perfectly acceptable for an aristocrat to say, "Bring me some prisoners," or "Bring me some orphans so I can test a vaccine on them." And this would involve intentionally infecting people with a disease. So, for instance, in 1722, Lady Mary Wortley Montagu was promoting the idea of smallpox inoculation for the British royal family. But there were concerns about the risk, so she first had the procedure tested on several condemned prisoners and 6 orphans. To give another example, in 1906, Richard P. Strong tests a cholera vaccine on prisoners in the Bilibid prison in Manila. The prisoners were not asked for their consent, nor were they informed of the nature of what was going on. They were, however, given cigarettes. Unfortunately, the research was very sloppy, and 13 prisoners were accidentally given the bubonic plague and died. Later, Strong went on to investigate the cause of beriberi by intentionally starving prisoners, again resulting in death. The real turning point comes in 1947 with the Nuremberg trials, where Nazi doctors were found guilty of horrific experiments on prisoners in concentration camps. Perhaps the most frightening of these was human vivisection. They would tie someone up and cut them open, conscious and without anesthetic, to observe the human body at work. There were also a lot of experiments that just amounted to killing people in different ways and watching how they died. For instance, Nazi doctors put people in freezing cold water to see how long it would take them to freeze to death. One doctor injected gasoline directly into the hearts of prisoners. The Japanese engaged in similar experiments on Chinese prisoners in World War II, including human vivisection at the ghastly Research Center 731. These experiments are not as well known in the United States because the doctors involved were never put on trial. You can bet they are remembered in China, though. In any case, the Nuremberg trials and the Nuremberg Code mark a major turning point in global attitudes toward human experimentation. People worldwide now start thinking in terms of informed consent. The ethics of informed consent did not catch on in America until much later. The turning point for American bioethics was the revelation of the Tuskegee syphilis experiments. These experiments were brought to light in 1972. Only the experiments themselves began in 1932. These were experiments performed on African Americans who did not give anything resembling informed consent. The goal of the experiment was to observe the natural progression of the disease in a patient dying of syphilis. So it was a lot like the Nazi experiments in that the goal was to observe how someone dies. African Americans with syphilis were recruited and then lied to about their diagnosis. They were told they had bad blood, which, isn't even really a disease. By the 1940s, just 8 years into the experiment, it was known that penicillin could cure these men, but the patients were denied treatment. In fact, they weren't even told about the cure, so that doctors could observe how they died. This experiment went on for 40 years and was completely open in the medical community. Papers were published describing the experiment in medical journals, and none of the doctors who published, edited, or read these journals said a thing. That is, until the 1960s, when a man named Peter Buxton, who worked for the U.S. Public Health Service, started raising objections. At first he tried to work within the system, but by 1972 he became so impatient with the inability of the medical community to police itself that he went to the news. He leaked the information to a newspaper called the Washington Star, which no longer exists. So, here he is. That is, until the 1960s, when a man named Peter Buxton, who worked for the U.S. Public Health Service, started raising objections. At first he tried to work within the system, but by 1972 he became so impatient with the inability of the medical community to police itself that he went to the news. He leaked the information to a newspaper called the Washington Star, which no longer exists. This series of articles in the Washington Star created an incredible controversy and led to the establishment of all of the safeguards we now have regarding research on human subject and, in general, protecting people's autonomy in medicine. The first important thing that came out of this was the Research Act of 1974, which established institutional review boards and the National Human Investigation Board. Right now, it is standard practice for every hospital to have an institutional review board, commonly called an IRB, which monitors the ethics of experiments going on in the hospital and other ethical issues that come up in the running of the hospital. The 1984 Act also established a national framework for regulating IRBs through the Human Investigation Board. A bit later, in 1979, a group called the Belmont Commission released a report which established a framework for all contemporary discussions of medical ethics in the United States. One of the things that it did was lock in the idea that patient autonomy was a central good. It is worth noting the connection between the rise of patient autonomy, the Tuskegee experiments, and the civil rights movement. In 1932, when the Tuskegee experiment began, this sort of thing could be done to African Americans because blacks didn't really have any rights at all. Doctors were not concerned with consent in general. However, while treating white patients, they acted paternalistically, that is, like a good parent, looking out for what they felt was the patient's interest. With African Americans, paternalism became exploitation. Now flash forward to the 1970s. The victories of the civil rights movement in the previous decade meant that this kind of exploitation was now intolerable. But this had the further effect of altering the way patients in general are treated. If you can't trust white doctors to treat black patients justly, maybe all relationships between patients and doctors need to be governed by informed consent. Once informed consent became the rule in medical experimentation, it also had to become the rule for ordinary treatment. It used to be that doctors would quite freely lie to patients about diagnosis or prognosis. Now this can lead to a malpractice suit. It used to be that decisions about when to perform CPR were entirely left to the doctor. Now we have DNR orders, do not resuscitate orders. It used to be that the doctors freely gave placebos as treatment. A doctor would say that they were prescribing a real drug and then write a prescription for sugar pills. These days, placebos are only used in randomized clinical trials where patients say in writing that they know that there is a chance they will be given a placebo. The consent form people sign in randomized clinical trials gets to the problem with the current state of autonomy in medical practice. Although the requirement for informed consent is enshrined in law and in official statements of medical ethics, in practice, informed consent is treated like a pointless bureaucratic hassle. Informed consent just means more paperwork to sign, which is particularly annoying in the United States, where we are already burdened with far more unnecessary paperwork than any other healthcare system. What's worse, lots of studies show patients often don't know what they're signing. This comes up especially in clinical trials, where patients often suffer from what we call the therapeutic misconception. The therapeutic misconception is a patient's mistaken belief that the purpose of a randomized trial is to benefit them rather than to gain knowledge, and that they are certain or likely to benefit personally from taking part in a clinical trial. In extreme cases, the patient may not even understand that the trial is randomized and that they may be receiving a placebo. It is clear now that the ritual signing of consent forms at the beginning of medical treatment is not creating meaningful informed consent in many cases, and this leads a lot of medical professionals and patients to become sour on the whole process. Although informed consent has many problems in practice, autonomy isn't going anywhere as a value in medicine, at least in Europe and America. This is because the emphasis on autonomy in medicine fits with general trends that we have seen in all ethical domains over the last few centuries of Western culture. Just as informed consent has become the watchword in medical ethics, consenting adults has become the watchword in sexual ethics. Once upon a time, sex was morally acceptable when two families agreed that a man and a woman should be married under the auspices of the church. The agreement was sealed when the bride's father turned her over to the groom in the presence of a priest. Over the course of the 20th century, this model has been replaced by one where the main thing that makes sex morally acceptable is if the parties involved are adults who can consent to sex and really do consent to sex. Something similar happens in government. Rather than saying a government is legitimate when a monarch can establish his connection to the royal family and to divine right, we now say that a government is legitimate when it is democratic. And the watchword for democracy is that a government has the consent of the governed. Well, all this to say that the rise of patient autonomy as a key value in Europe and America fits with the rise of autonomy in Western culture in general. Okay, let's look at some cross-cultural issues in autonomy. What is true of the West is not true of the whole world, however. Other cultures around the world don't put as much emphasis on individuality as we do in the West, and that carries over into medical decision-making. One of your readings for this section was a study by Blackhall et al. On attitudes toward patient autonomy amongst people of different ethnicities. What they found is that African American and European Americans made decisions in a very similar fashion. They wanted to be told the truth about their diagnosis. They wanted to be told the truth about their prognosis. And major decisions were to be made by the patient and not anyone else. Amongst Mexican Americans, and especially amongst Korean Americans, there was noticeably less desire to be told the truth about your diagnosis and prognosis, and a much stronger sense, especially among Korean Americans, that it is the family and not the patient who should make major decisions about treatment, for instance, whether to go on life support. Notice how these two kinds of questions Questions about being told the truth and making your own questions about making your own decisions go together. If you think of yourself as the one who is making decisions, you're going to want to know the truth. Conversely, if you know the truth, you're going to want to make decisions for yourself based on that knowledge. So, both knowing the truth and making your own decisions are part of a general model of autonomy. What this survey shows is that the trend to put this kind of autonomy front and center in medicine has not extended globally. Korean Americans aren't the only ones to put less stock in the idea of autonomy. One of the readings I assigned from the text is Ethical Relativism in a Multicultural Society. There she gives many examples of people coming from all sorts of places with all sorts of attitudes about autonomy. One of her more interesting examples is the case of traditional Navajo people who have strong taboos against speaking negatively. To some extent, this is something that anyone can recognize. We all have experienced the power of positive thinking. But for some more traditional Navajo, thinking positively means not even mentioning negative outcomes of a course of treatment. This runs smack into the requirement that physicians get informed consent before treating a patient. Macklin gives the example of an elderly Navajo man who might benefit from heart bypass surgery. But his daughter informs the doctors that even mentioning the risks of the procedure will cause her father to reject the surgery because speaking of complications from surgery can cause them to happen. Now, this Macklin article is fairly old, but the situation with the increasingly aging population of traditional Navajo is unchanged. This picture here is actually from a 2011 New York Times article about the difficulties of end-of-life decision-making among a people where talking directly about death is taboo. Macklin's arguments about this case are really interesting. She says that one should withhold information from the patient and even suggests that autonomy means something different for traditional Navajo. We may define autonomy as acting voluntarily with adequate information, free of external and internal constraints. But according to Macklin, a traditional Navajo acts autonomously when they act voluntarily with only positive information and are free from internal and external constraints. This is a fascinating claim, and it is actually the basis for the first discussion question I posted to the Section 1 discussion forums. Macklin's essay raises the issue of ethical relativism. Macklin is essentially saying here that the notion of autonomy is relative to culture. It means one thing in one culture and another thing in another culture. The idea that what counts as real autonomy or true autonomy for everyone just doesn't hold. It is important to note, though, that in most contexts, Macklin is opposed to relativism. She gives the example of the Santeria practice of spreading drops of mercury around the house to ward off evil spirits. Macklin does not think that this practice is a good idea for practitioners of Santeria and a bad idea for everyone else. It is simply universally bad. Mercury is poisonous for everyone, no matter what they believe. So we need to look in detail about what ethical relativism is. Your textbook has a discussion and criticism of it on pages 36 to 38. In general, relativism is the belief that ethical statements are only true relative to something else, generally a culture. The idea is roughly that Korean Americans have their way of making decisions, and European Americans have their way of making decisions, but no one has the one right way of making decisions. This is often captured by phrases like, what's true for you isn't necessarily true for me, and generally this is invoked as a way of stopping conversation. It's all just opinion, there's no use talking about it. This is easy enough to believe when it comes to some issues, like the role of family in healthcare decisions. However, relativism is a much bigger claim about all ethical beliefs. For instance, some cultures have practiced slavery. Others allow infanticide for healthy infants. One contemporary practice that has gotten a lot of attention is female genital mutilation. The practice in some parts of Africa of removing part or all of the clitoris of female infants or otherwise altering their genitals in order to ensure that they are pure and remain virgins until marriage, because, for instance, they do not enjoy sex as much. Female genital mutilation is considered a violation of human rights by the United Nations World Health Organization. The ethical relativist, however, would maintain that no one from an outside culture has the right to criticize this practice or say that it is wrong. It is important to be clear on what is being claimed here. There are really two kinds of relativism which often get confused. Descriptive relativism is an uncontroversial thesis about what people believe in different cultures. As a matter of fact, Korean culture places less value on individual autonomy than Anglo-American culture. As a matter of fact, the Maasai practice female genital mutilation and other people do not. Normative relativism goes a step farther. Not only do people have a disagreement here, but neither side can be said to be correct. The statement, female genital mutilation is a violation of human rights, is neither true nor false on its own. It is true relative to American culture and false relative to Maasai culture. You can compare ethical relativism to relativism about scientific statements. Some people, the ancient Greek philosopher Anaxagoras, for instance, have believed that the earth was flat. These days we believe the earth is round. Descriptive relativism would simply note the difference in these beliefs. Normative relativism would go farther and say that there is no right or wrong here. The earth is flat for Anaxagoras and round for us. The distinction between descriptive and normative relativism lines up with the distinction between descriptive and normative statements we saw earlier. A descriptive statement was a statement about the way the world is, and a normative statement was about the way the world should be. Similarly, descriptive relativism notes that disagreements exist. Normative relativism says we shouldn't try to resolve them. One important thing to note is that descriptive relativism does not imply normative relativism. Just because differences of opinion exist doesn't mean that no one is right. Normative ethical relativism also needs to be distinguished from simple multiculturalism. The term multiculturalism gets used in a lot of different ways, but for the most part it signifies a simple belief in tolerance. We can define multiculturalism just as the claim that in a society composed of many subcultures, one should try to be tolerant. This is different than saying there is no right answer to any issue. It is merely saying that on some issues we should let people go their own way. Full-blown normative relativism is a threat to philosophical ethics because it says that the issues we are trying to resolve are fake. There are no answers to the questions we are asking. As you might expect then, your textbook authors take time out to show that normative ethical relativism is not a tenable position. They give four arguments here, and I'm going to outline. They give four arguments, and I'm going to outline them here. You will need to know these arguments for the test. I'm labeling these the argument from self-refutation, the argument from extreme counterexamples, the argument from moral change, and the argument from moral subcultures. I'm going to present these arguments in canonical form with premises and conclusions marked. See the presentation on argument for the details about what this means. So, the argument from self-refutation. Suppose we believe in moral relativism. We believe that all moral statements are only true relative to culture. If we believe in moral relativism, we should promote the view that all moral views should be tolerated. But many cultures do not believe in universal tolerance. For instance, recently in Sudan, a woman named Miriam Yeha was condemned to be hanged to death because she married a Christian man, but the government of Sudan considers her a Muslim, and according to them it is illegal for a Muslim to abandon the faith by marrying a Christian. In any case, cultures do not practice universal tolerance. Therefore, we can't promote the view that all moral views should be tolerated. If we're ethical relativists, tolerance is only of value relative to our culture. Well, this is a contradiction, right? Therefore, we cannot believe in moral relativism. Moral relativism refutes itself when applied to itself. Basically, people are attracted to moral relativism because they want to promote tolerance. However, moral relativism actually forbids you from promoting tolerance, so it completely undermines itself. Another way of putting this argument is that normative ethical relativism is itself an ethical view. Therefore, by its own rights, it's not really true. It's only true relative to some cultures. Okay, the argument from extreme counterexamples. Suppose normative ethical relativism were true. All of these arguments start this way. Then we would be required to say that slavery, the Holocaust, and all sorts of other horrible things were okay. Well, no one wants to say that slavery, the Holocaust, or anything like that was okay. Therefore, normative ethical relativism cannot be true. The argument from moral change. Suppose we believe ethical relativism to be true. Moral statements are only true or false relative to a culture. Well, now, cultures change over time. In the United States, slavery used to be acceptable, but now it is not. If ethical relativism were true, the abolitionists would have been morally incorrect in their views simply because they were in the minority. If ethical relativism were true, the abolitionists would suddenly have become morally correct as soon as Lee surrendered at Appomattox. None of these things seem right at all. Therefore, normative ethical relativism is false. All right, the last argument the book presents is the argument from moral subcultures. Suppose normative ethical relativism were true. If moral statements were only true relative to a culture, then we would be able to identify a unified culture that makes those statements right or wrong. But cultures are always complicated entities full of contradictory subcultures. Iran, for instance, is often said to have a culture with strict rules about how women should appear in public. They are supposed to dress modestly, cover their hair, etc. But there are a lot of people in Iran, perhaps even a majority, who hate these rules and would like to see them changed. So which is the subculture, which is the culture that ethical statements are relative to? Well, therefore, normative ethical relativism is false. There is some overlap here with the argument for moral change, especially the way the book presents it, because any moral subculture might become the dominant culture. I've tried to keep these arguments separate by emphasizing in this one the simple fact that moral relativism requires us to pick a unified culture, but there isn't one to pick. Arguments of the philosophers. We're going to look in detail at two of the philosophers you were assigned to read, John Stuart Mill and Howard Brodie. For your reading, I had you go through some excerpts from John Stuart Mill's essay on liberty. There is also a guided reading exercise online. Here, I'm just going to outline some of the major arguments. This first slide is an outline of the essay itself in 5 chapters. There is an introductory section where Mill outlines its thesis and talks about the importance of the issue. The next section is called Of Liberty and Thought and Discussion, which is specifically, as you might expect, about the freedom of speech and the importance thereof. The central chapter is called Of Individuality as one of the elements of well-being. Then he talks about the limits of authority of society over the individual and goes over some applications. Okay. In the introduction to this book, Mill has some very interesting things to say about why liberty needs to be talked about at all. You might say, hey, I live in a democracy. I know I'm free. I don't need to think about this. But Mill insists that simply having a democratic government is not enough to ensure liberty. This is something that's important to understand in order to grasp where Mill is coming from, and also important for us to understand today. Mill was writing almost 200 years ago, at a time when democracy was making a great deal of progress in England. Mill was an Englishman. He was a member of Parliament. At the time, there were property requirements on who could vote, and women could not vote. Mill was an advocate for full voting rights for everyone, including women. So he is writing in a context where you might think that full freedom is close to being secure. And one of his points in the opening is that even if we did manage to get full voting rights for everyone, liberty is not guaranteed. And this is something we need to remember today. We as Americans tend to think as long as there are free and fair elections, liberty is guaranteed. Mill did not think that this was the case at all, and he gives some pretty persuasive arguments in this opening section for it. First of all, he says democratic government isn't really self-government. It is actually an avenue by which some individuals in a country can govern other individuals in a country. The self-government that is spoken of is not the government of each by himself, but of each by all the rest. What democracy gives us is an avenue to interfere in each other's lives. What is particularly worrisome for Mill is the possibility of the tyranny of the majority. The tyranny of the majority is an important idea. It is simply the idea that the majority of a population can itself become a tyrant over a minority, either an ethnic minority or a religious minority, or simply a minority in opinion. This is as much a problem as regular dictatorship. So, it is the possibility of tyranny of the majority that leads Mill to set up his harm principle. And here it is again. The only purpose for which power can be rightfully exercised over any member of a civilized community against his will is to prevent harm to others. His own good, either physical or moral, is not sufficient warrant. Mill also introduces a phrase called the sheltered realm. This is the realm of your life that is protected by your autonomy. He says there are three elements to the sheltered realm. One is freedom of conscience, and this includes freedom of speech. This is basically your ability to think freely, to talk freely about any ideas. This includes freedom of religion. Perhaps more interestingly and more importantly, the sheltered realm includes a freedom of life plan. You are free to plan out your future any way you want to, and this includes taking unusual paths through life. Mill lived long before the era of gay marriage would ever be considered. But had Mill been introduced to the idea of gay marriage, he would consider it part of your life plan and would thus be protected from outside interference based on his harm principle. Finally, the sheltered realm includes freedom of association. You have to be able to mix with people of a like mind in order to develop your autonomy. The next chapter of Mill's essay is On the Freedom of Thought and Discussion, the first part of his sheltered realm. His thesis here is that it is as much a crime against humanity to censor an unpopular view as it is a popular one, and this again fits with his worries about the tyranny of the majority. The idea is that we don't have to worry so much about that the government is going to try to suppress a popular idea. A democratic government will in all likelihood promote the ideas held by the majority. They will, however, try to suppress ideas that are unpopular. They will, based on the will of the majority, get rid of unusual religions, unusual sexual practices, whatever. So here's his thesis. Even the most legitimate of governments, one which expresses the will of the people perfectly, cannot restrict speech. His argument is really nice here. It's an argument by dilemma, as we call it. It begins with an or statement. If you repressed speech, one of two things happens. Either you repressed a true idea or you repressed a false one. If you repress a true idea, you deny humanity the truth, and obviously have done a harm to humanity. What's really interesting, though, is that if you repress a false belief, you also do a harm to humanity. You deny humanity the chance to understand the truth more deeply by seeing how it is contrasted with falsehood. There's a wonderful section of this essay where he talks in great detail about how you don't understand your own beliefs unless you understand the other side. You may think you know the truth, but unless you understand the false belief it is opposed to, you don't really know the truth. Either way, though, repressing speech hurts humanity, and therefore speech should never be repressed. This is a different diagram of the same argument. The point here is to illustrate that this is an argument by dilemma. You establish an or statement at the beginning of the so-called dilemma, this or that. Then you show that both sides of the dilemma lead to the same outcome, and therefore the outcome must be true. So here we begin with the idea that you try to repress an opinion. Then the or statement is that the opinion is either true or false. On the left side, we imagine that the statement is true. Then we see that we have robbed humanity of the truth and therefore have robbed humanity. On the right side, we imagine that the statement is false. In this case, we have robbed humanity of the chance to better understand the truth by understanding the other side of the issue. So again, we have robbed humanity. Either way, you have robbed humanity, Therefore, you should never suppress an opinion. The central chapter of Mill's On Liberty is called Of Individuality as one of the elements of well-being. This is actually a crucial chapter to the book. It is often neglected, though. People don't realize how important this chapter is. Basically, what Mill asserts here is that humans require freedom to be happy. This is crucial for him. He would not be able to argue as firmly as he does for the need for freedom if we could be just as happy without freedom. Mill is a utilitarian, which you will remember from video 2 is a kind of consequentialism that says actions are good to the extent that they maximize happiness. So Mill cannot argue that freedom is a necessary good unless he can argue that it is necessary for happiness. So this is his argument. The goal of human life is not the satisfaction of passing desires. It is not simply pleasuring yourself. The goal of human life is the satisfaction of our deepest needs. And these needs are only satisfied through self-cultivation, through study, through bettering yourself. I find that people in college can sympathize with this idea right away. The idea that an important part of being alive, of being fully human, is bettering yourself. That is part of your happiness. Well, self-cultivation requires freedom. Therefore, humans require freedom to be happy. In the remaining parts of Mill's essay, he elaborates his thesis, adding some important details that need to be worked out, such as what counts as a harm. We've said that you can only interfere with someone's autonomy to prevent harm to others, but what counts as harm to others? Mill has a list here. Encroaching on someone else's rights. Inflicting loss or damage not justified by your own rights. Lying to people. Unfair or ungenerous use of advantages over others. Now, this one is interesting. He's thinking here of situations where one person, by chance, has a lot of power over another, and he uses it to really take advantage of the other person. For instance, imagine that there is a natural disaster like Hurricane Katrina, and there's a shortage of drinkable water. If I happen to have a lot of it, I decide to start charging people $500 for a gallon of water. That's price gouging, and Mill says it counts as a harm. The last item here is selfish abstinence in defending others against injury. This, as I said before, shows that for Mill, the harm principle actually includes the social welfare principle. And this is here to justify things like taxation. Refusing to pay your taxes counts as harm to others. Mill also talks about what you can do when people act badly but do not harm others. He says that you cannot force them to stop what they are doing, but you can make fun of them, avoid their company, argue that what they're doing is morally wrong. This is because the things you can do aren't really punishment. All these things are just the natural consequences of whatever act you're criticizing. So if you don't like the way someone is living their life without hurting anyone else, you can just stay away from them. The other thing that happens in the 4th chapter of the book is that Mill deals with objections and replies. We'll end this section by looking at these and skip the last chapter on applications. So, here's an objection. Any harm to yourself is a harm to others. That is how interconnected society is. Mill replies that we can draw lines. A nice example, no one should be punished for being drunk, but a policeman can be punished for being drunk on duty. Well, you might object that if we can intervene in the lives of children, why not adults who act like children? Mill says that if the cost of allowing adults to act like children is spread out over society, it is a cost society can bear. For instance, if you allow people to not wear motorcycle helmets, it will cost society by raising insurance rates. But that's spread out across society, so it's a cost we can bear. Finally, Mill suggests that paternalist interventions might be limited to ordinary restrictions of prudence. Aren't there mild ways that we can intervene that are fine? And Mill replies that when society interferes with people's lives, it generally interferes wrongly and in the wrong place. So this is an important idea for Mill. The government just is not a good parent, and therefore it shouldn't try to act like a parent. All right, so that's Mill. Let's take a look at Brodie. The other argument from a philosopher I want to look at is from this reading by Howard Brodie on the transparency model of informed consent. This was taken from an article written a while ago and was later incorporated into a book called The Healer's Power, which came out in 1993. Brodie is a philosopher and a physician, and he has some direct insight into the dynamics of obtaining informed consent, all of which still apply today. His basic question is, what counts as getting informed consent? Or, to put it another way, how do we know as medical professionals that we have obtained proper informed consent? He considers several ideas before settling on what he calls the transparency standard. The first two are standards used in the law, an older one that isn't used so much, and a newer one. The older one is the community practice standard. It says that we have obtained proper informed consent when the doctor has told the patient what other doctors in his community would have told that patient in similar circumstances. The newer one is the reasonable patient standard. It says informed consent has been obtained when the doctor gives all the information a reasonable patient would need to know in order to make an informed decision. You can see how the evolution of the law reflects the patient autonomy movement here. With the old standard, rules are entirely set by doctors. With the new one, rules are set by patients. The next standard was suggested by J. Katz in a book called The Silent World of Doctor and Patient. This isn't so much a standard as a loose metaphor. Katz says doctors should simply have a conversation with patients, and the normal rules of conversation are enough. This isn't really much of a standard, and we won't deal with it further. Brodie's own standard is the transparency standard. The key to this is that the physician has informed the patient about what motivated her to recommend a treatment. The doctor is transparent about her own reasoning. The two standards that have been used in the law both have serious drawbacks, according to Brodie. The old community practice standard leaves the door open to huge amounts of paternalism. If it isn't a community practice to reveal a risk, the doctor doesn't have to do it. The standard also just rewards conformity for the sake of conformity. You don't need to think about what the right thing to do is. You just need to do what everyone else is doing. The reasonable patient standard does better. Reasonable person standards are used widely in American law. They are used in other kinds of negligence cases. For instance, in deciding whether a reasonable person would have fixed the crack in the sidewalk that someone tripped over. Brody thinks that the reasonable patient standard does not work well in the current environment with everyone filing malpractice lawsuits left and right. He also doesn't think it works well in primary care settings. The basic problem is that doctors feel they have to treat informed consent as an exercise in covering their backsides. Every possible outcome, no matter how unlikely, has to be listed in advance, lest something bad happens the patient wasn't told about, allowing the patient to sue. The doctor has no parallel incentive to talk about positive outcomes, so the process distorts the information the patient is given. It also becomes more important for the doctor to document procedure rather than actually doing it well, since after all, the whole point is to insure yourself against lawsuits. All of this is somewhat manageable in a tertiary care setting, where the practice does a small number of procedures and there's a lot of time before each procedure. But it doesn't work well in the primary care setting, where you don't have these luxuries. The problem with the reasonable patient standard is that doctors have no way of knowing if they have said enough about the procedure. How many warnings should they give? Brody's solution to this is for the doctor to be transparent about her own reasoning. In other words, the doctor should tell the patient about all the possible downsides that the doctor herself was considering before she recommended the treatment. Thus, the doctor's own expertise can be used to decide how much informed consent is enough. More specifically, the transparency model of informed consent looks like this. A patient counts as reasonably informed if 1. The physician discloses the basis on which the proposed treatment or alternative possible treatments have been chosen. 2. The patient is allowed to ask questions suggested by the disclosure of the physician's reasoning, and those questions are answered to the patient's satisfaction. This standard is remarkably simple for physicians to implement. The doctor simply needs to repeat her thinking to the patient out loud and in a language understandable to the patient. Brody also points out that this allows doctors to go easy on the disclaimers for routine procedures in a primary care setting. If a well-trained family doctor knows that certain risks are negligible in this common situation, she won't have to tell the patient about them because they weren't playing a big role in the doctor's own decision-making. Brody also emphasizes the advantages this gives to the patient. Because questioning is built into the standard, the patient can control how much information they feel they need. All right, that's it for the presentation on autonomy. What do you think of the issues we've covered? You should voice your ideas in the discussion forum. So here's some things that you can think about. How much paternalism is justified in medicine? How should autonomy be handled in cross-cultural situations? Which is better for the understanding of informed consent? The transparency standard or the reasonable patient standard? I hope to have a conversation with all of you about these topics and more. Thank you.